Hello students. In the previous lecture of jurisprudence, we had started the ancient theories of natural law. And in the previous lecture, we had studied the ancient theories of natural law from the point of view of Greece. And now in this lecture, I am going to discuss with you the ancient theories of natural law which was prevalent in Rome. In Rome, Stoics, who was the very famous jurist, built up his theory of natural law on the theory of Aristotle. But what he has done, he has transformed this theory into an ethical theory of natural law. According to Stoics, the entire universe is governed by reason. And man's reason is the part of the universal reason. He lives according to the nature. Therefore, it is the moral duty of man to subject himself to the law of nature because man is a part of the universal reason. The law of nature is of universal application, and this law of nature is binding on all men of universe. So all types of positive law must conform to the natural law according to the theory of natural law given by Stoics. So what was the influence of natural law theory in Rome? The theory of natural law given by Stoics affected the great legal developments in Rome. The theory of Stoics exercised great influence upon the jurists during the Republican period, and some of them paid high esteem to the concept of natural law. In Rome, the theory of natural law did not remain confined only to the theoretical discussions only, because Romans were very practical people. They used the concept of natural law to transform their narrow and rigid system of law into a cosmopolitan one. What is the meaning of cosmopolitan? Cosmopolitan means a country consisting of people from many different countries. By using the concept of natural law, Romans give citizenship to foreign citizens as well, except few class of people. In this way, natural law exercised a very constructive influence on the Roman law. There was three divisions of law in the ancient Rome, which is as under. The three divisions of law was jus civile, jus gentium, jus naturale. Jus civile was the civil or positive laws which were enforceable by the courts of Rome to regulate the relationship between Roman citizens themselves. Means to say, these laws had no application to non-citizens of Rome, whereas jus gentium was a part of the positive law of Rome. That means to say, it was a part of jus civile of Rome. Though, when we are going to talk about the application of jus gentium, then it was much wider in scope than jus civile. And third division of law was jus naturale. It was the law of nature. Although it had no legal validity in the courts of Rome, yet it formed the foundation base on which jus civile and just gentium were based in Rome. Basically, jus civile was only for Roman citizens, but on natural law principles, Roman magistrate applied those rules which were common with the foreign law to foreign citizens also. I want to repeat. Although jus civile was applied to Roman citizens only, but on the basis of natural law principles, Roman magistrate applied those part of the rules of jus civile which were common with foreign law to foreign citizens also. The body of law which grew up in this way by applying to the foreign citizens. The body of law which was applied to the foreign citizens on the principles that these principles were common with the foreign laws was called jus gentium, and it became a part of the Roman law thereafter. Later on, when citizenship was granted to foreign citizens also, then jus civile and jus gentium became one when Roman citizenship was extended to all except few classes of people. And what was that few classes of people? That were the slaves who was not given citizenship in Rome. So, still Roman did not incorporate natural law into their positive laws because slaves were still deprived of the benefit of the new law. Even the Roman lawyers did not bother themselves with the problem of conflict between positive law and natural law. Even when the positive law do not contain the principles of natural law, Roman lawyers did not bother this, though there were some jurists in Rome who considered natural law superior in comparison to positive law. And they also suggested that in case of conflict between natural law and positive law may be disregarded and natural law will prevail over the positive law. This was the thinking of some jurists only. But majority of the jurists in Rome, however, did not enter into this question, and they were not applied the natural law in positive law fully. So this was something. The ancient theories of natural law in Rome. If you really like my lectures, then kindly subscribe my channel to get notifications of all my videos. If you want to get the notes of my law lectures, then you can go to Google and type law articles 2020.blogspot.com. After typing this, you will enter in my blogs and get all the notes of my lectures. Thank you very much.